Hi, I'm Teana Baker Taylor, and thank you for joining us for Governance and Guardrails, our segment where we talk about legal and regulatory issues affecting digital assets. I'm delighted today to be joined by Stephen Palley, the infamous advocate and healthy skeptic of digital assets. Stephen, thank you so much for joining me today.
You're very welcome. I'm glad to be here, and I'm glad to be infamous too.
Yeah, absolutely. Where are you today in the world?
So I'm in a suburb of Washington, D.C. called Chevy Chase. It's inside the Beltway. So if you're familiar with D.C., I'm about 6 miles or so from the White House, which is much more detail than you asked for, but what the heck.
Hey, no, that's okay. Just as long as there's not too much detail so that people can find you. So today we're going to be talking about a recent decision by the Ninth Circuit Court of Appeals in the U.S. Some of you may remember the story a couple of years ago about Thomas Costanzo, hope I pronounced his name right, who was convicted in 2018 for selling Bitcoin for dollars, unfortunately to some federal FBI agents who were posing as drug traffickers. Yes, oops. So he was sentenced to 41 months in prison, which makes perfect sense to me on the face of it because he was clearly laundering money, or so it would seem. He was convicted using a federal AML statute, and he's appealed the verdict. So I think the first thing, Stephen, can you give us a sense of, for those who aren't in the U.S., state versus federal jurisdiction,
Sure.
who is the Ninth Court of Appeals, and what Costanzo's appeal actually argued?
Yeah, absolutely. So the United States is a federal system. We've got states and we've got the federal government. And way back in the 18th century, when the United States was formed, there was basically states were, you can almost think of them as separate and individual countries. Yeah. Initially, they were gathered together in something called the Articles of Confederation, which was too loose. And then there was a constitution. And we're actually, sort of as a sidebar, seeing some of that tension now between the federal and state governments in response to COVID. Like
definitely, yeah.
There's a doctrine in the United States called the doctrine of co-equal sovereigns, which basically says that, for the most part, the states and federal government are equal. They're equal governments with equal power. That is not true for constitutional purposes when it comes to things like entering into treaties. And there's we don't really have time for me to talk about the Supremacy Clause. But just sort of suffice it to say, states and federal governments are co-equal sovereigns, and they've got their own different sets of laws.
Okay.
States generally have something called they've got a police power, which allows them to control or set laws to govern things like marriage, sort of intrastate or inside state health, safety, and well-being. Mm-hmm. So in order for a federal criminal law to be implicated, you have to implicate one of the federal government's powers. And most frequently, interstate commerce has been, under the Commerce Clause of the Constitution, has been the way that federal criminal statutes have been justified, which brings us, finally, right, to the case that you asked me about. And I think you asked me to explain what the Ninth Circuit was.
Yeah, please.
Okay, so the American courts, the federal courts, which are separate than state courts, so we've got federal court system and a state court system. Federal courts are divided into really three levels. There's some nuance to that. There's arguably a fourth, magistrate judges, but from constitutional purpose, you have federal district courts, which are the trial courts. You then have circuit courts of appeal, which are made up of different federal districts, and then you've got the Supreme Court. So if you lose in district court, you take an appeal to the federal circuit where you're located. There's like my constitutional law professor would probably like mark me down for leaving out some nuance and details, but that's basically the way it works.
We're looking for context, so that's okay.
Right. So like the Ninth Circuit Court of Appeals is the court that governs, or is the Court of Appeals you take an appeal to if you're out on the West Coast. And there's some states that are not exactly on the coast that are part of it too, but so California, for example.
Yeah.
If you lose in federal court, in the Northern District of California, which is in San Francisco, which is where a lot of technology litigation happens, you would then take an appeal to the Ninth Circuit. And that's basically, I think I answered your question. I rambled on.
Yeah, no. So let's dig into this a little bit. So on the face of the evidence, Costanzo appears guilty, right? He had a high profile on local Bitcoins. He was dealing in huge amounts of money, $15,000 to $50,000, huge to some people. And as I understand it, federal agents had been investigating him for a number of years, right? And they told him that they were going to be using the Bitcoin that they bought from him to facilitate drug trafficking. Right. So all of this is sitting within the evidence, and he gets convicted. But I think what is interesting here, and I would like you to explain why this is interesting, is we have federal agents looking into the sale of something that appears to be happening interstate. So typically the FBI doesn't get involved unless you cross state borders, right? And this is where these interstate laws are coming into play when it has to do with the exchange of Bitcoin for dollars. Am I right there?
Well, sort of, yeah. So this guy got convicted under federal anti-money laundering statute, which is, for all of you lawyers out there, that's 18 U.S.C. section 1956. And this fella who had a profile on local Bitcoins under the name, I love this, Morpheus Titania.
Oh, yeah.
You think somebody watched The Matrix, maybe? He also, his profile said it was Bitcoin was the honey badger of money and the most fearless currency with no regard for national borders anywhere and protected by encryption. Okay. Not protected by from stupid, though, apparently. Right. So this guy, he, agents reach out to him and say they want to buy Bitcoin. Mm-hmm. And at various points they say, we're going to use it to buy drugs. And he's like, I don't need to hear about that. That's also, as an aside, that you don't, but you don't want to know. That's known as, that's the doctrine, that's willful blindness, and that doesn't usually work. Anyway, he gets convicted, and whether or not he should have been or whether or not the law is just is a different conversation. He gets convicted and he takes an appeal to the Ninth Circuit from his 42-month sentence in federal prison. He says, you didn't prove that this is something that happened in interstate commerce. Basically what happened was this guy, the agent gave, in one instance, the agent Klepper was his name. I'm looking at the opinion. Gave Costanzo $13,000 in cash. Costanzo transferred Bitcoin to the agent to his phone. Okay. Essentially, is the way the court describes it. The next month, this happened again. And what Costanzo said was, he was like, look, there's no interstate commerce nexus. This was peer-to-peer from one phone to another. So therefore, you didn't prove interstate commerce nexus necessary to apply the statute. And the Ninth Circuit said, look, I mean, it might have been what you call peer-to-peer, but you sent communication over the internet. And there's pretty well-established law that says using the internet can create an interstate commerce nexus. And what's more, we understand that this thing, Bitcoin, it's recorded on a blockchain, which exists everywhere in the world. And to me, I didn't think the analysis was that hard to get to if you're familiar with sort of the jurisdictional, the case law on jurisdiction. But it is really interesting, in my mind, to realize that in the court's view, and it took maybe a page or 2 pages to reach this conclusion, the court's like, no, Bitcoin, the very nature of a Bitcoin transaction is that it implicates interstate commerce. Now, if you think about it and you spin the thread out, if I pay somebody $25 to mow my grass, right, there's no interstate commerce nexus, right? I'm giving you greenbacks, filthy fiat, stinky fiat covered in cocaine and blood. But nonetheless, I'm giving you money, and
But that's issued by the federal government, right? So is the instrument.
But that doesn't matter from an interstate or intrastate standpoint. That transaction, the fact that you use cash, doesn't trigger in and of itself for that transaction federal law. Now, it happens that if you follow it, I think there's a Twitter account called One Law Every Day. If you're creative enough, you can always find a federal law that somebody's breaking. We're probably breaking a law right now, like if we really wanted to dig. But as a practical matter, for in most instances, nobody would think of that as being interstate. It's intrastate. And on the other hand, using Bitcoin, if you spin this court's thread out, it seems to mean that every time you use Bitcoin, you're implicating federal jurisdiction. Now,
So let's say that the federal agent, and maybe you know this, I don't, is in that state. So, to make the exchange, potentially, it's done over the internet, could be done over a beer in a pub. You know what I mean? They could both be in the same state. So if you and I are both in Los Angeles and we do a peer-to-peer Bitcoin transaction, we're still within the federal jurisdiction because Bitcoin exists on the internet?
I mean, I guess it would depend on the transaction, and you'd have to figure out whether or not somebody was interested enough in going after you. But as I read this court's opinion, the conclusion seems to be use of Bitcoin to consummate a transaction where the transaction otherwise violates an existing federal law. The fact that you used Bitcoin for the transaction would seem to be enough in some cases to trigger federal jurisdiction. Man,
okay, so is this AML enforcement? Which, I think we all agree we don't want any type of, funds of any kind, whether it be Bitcoin or dollars or, chickens, to be used to facilitate money laundering and terrorist financing, right? That's not good. But is this in response to trying to find a reason to enforce something? Or is this an AML infraction and then looking for the easiest way to put that enforcement into place?
No, I mean, there's no policy reason here for the court's ruling.
Okay.
Courts don't, in the vast majority of cases, courts are not thinking about broader policy considerations. This judge's job was to say, was the burden of proof satisfied? Did the facts meet the jurisdictional nexus for the statute? Yes, they do. Now, under the doctrine of stare decisis, which is a fancy way of saying precedent, this case is now precedent for other courts, trial courts, district courts within the Ninth Circuit.
Yeah.
So it's binding precedent. Now, it's probably distinguishable on the facts from other cases that are brought before the court, but you can certainly see a future trial court when this issue is being raised saying, well, the Ninth Circuit is the Ninth Circus. I like that. The Ninth Circuit has already told us that Bitcoin transactions take place in interstate commerce.
Okay, so that leads me to my next question, which is, what's the impact? What could this potentially mean for future trading, transmission, for the market overall on the transfer of digital assets in the future? What could this potentially mean? The precedent of this ruling.
Well, I mean, what's that?
Hypothesize for us.
Well, we already have a pretty broad, pretty broad coverage by federal law of financial transactions under the 1970 Bank Secrecy Act, which is the thing that governs exchanges. And every state except, I believe, one has their own MSB licensing regime. I don't know that it really changes much for...
Well, in the peer-to-peer space, though, that's largely unregulated.
Yeah. Well, it's funny. Whenever I hear somebody say something is unregulated, my conclusion is that they just haven't looked to see what regulations might apply. And arguably, that's the case here. I don't think this has much impact on financial services in and of itself, because that is already so understood to be so heavily regulated. Does it have anything to do? So I guess the question would be, what about non-custodial wallet providers? I'm not sure it has much impact on them either. It's hard to say, honestly. Like, I want to give you an explosive, this will change the world conclusion. I'm not sure that it does. I think it's just it's another brick sort of in a wall of jurisprudence about like what this stuff is and what the transactions are. And a court is saying these transactions appear to happen in interstate commerce. So that would mean that I suppose my business transaction with somebody within my state where I use Bitcoin arguably implicates or creates a nexus to federal law, even though neither of us have left the state, simply by use of the use of Bitcoin. Now, the same thing could be said, however, of using a wire. So if I'm in Maryland and I wire money to somebody else in Maryland, I believe, though this is not something I deal with on a regular basis, I'm not a criminal law guy at this point in my career, that would probably nonetheless implicate interstate commerce and implicate the federal wire fraud statute.
Yeah.
Even though we're both within the same state, because we're using instrumentalities of interstate commerce for the transaction. Same thing with using a telephone or using a computer and internet. So, what's interesting is, new technologies come along and people say, oh, everything is different. The world has changed. Laws don't apply. And this is just an example of how that's not true. The court looks at it and they're like, walks like a duck, sounds like a duck. I guess it's a duck, right? We can always find a way to place things into existing categories.
Yeah, absolutely. And I think that, we hear that time and time again, that we don't automatically need a whole new set of laws to deal with digital assets or to work with them. But sometimes maybe it's the interpretation, and is the interpretation always fit for purpose?
We might need new laws, and laws will develop. They take time. I guess what this does is this belies the notion that, what did he say this was? That this was the most fearless currency with no regard for national borders anywhere and protected by encryption.
Fearless is good.
Fearless is good. And hopefully, whether or not somebody should be spending 3 years in prison for this, I'm not so sure it's a great use.
Not for us to say.
Yeah,
Stephen,
right.
Thank you so much for breaking that down. I thought that was a fascinating case. And the next time another doozy comes up, we will absolutely give you a ring back and see if you can break it down for us like we've done.
Oh, goody. Had fun.
So how can our watchers get in touch with you should they have any questions for you about digital assets or any other legal interest that they may have?
Sure. So you can reach me via email at spalley, Palley, at Anderson, ANDERSON, feel free to follow me on Twitter. I'm at Stephen D. Palley. I apologize in advance for my bad dad jokes and herring memes, but I do talk about crypto and law in that Twitter feed from time to time. And I write a column for the Block Crypto as well. So
awesome.
Always happy to hear from folks.
Awesome. Great. Thank you so much for joining us today, Stephen.
Thank you. It was fun.